Hello students, today's topic of discussion is auction sales. This is the last topic under the Sale of Goods Act and it talks about a special mode of sales which is auction sale. Auction sale is a special kind of a sale in the sense, in this case, the sale is done in public. It is a public sale. It is a public sale in the sense that in this case, seller, instead of approaching one buyer, he approaches multiple buyers by advertising about this auction sale, and all those buyers who are interested, they will appear to take part in the process of auction sale, and then on the basis of the auction conducted, one of the buyer will be selected to sell those goods. So auction sale is the sale in which different kind of buyers, they will be intimated about this sale and different terms and conditions of this sale through an advertisement, and these buyers are in this case called the bidders, because in this case whosoever is coming and attending and participating in the auction sale, they are going to give bid for the purchase of the goods that they intend to buy. So one after other, all the bidders will give their bid of price, and the person giving the highest price, he will be given the sale of the goods. So in this case, this kind of sale is because having some special kind of features, so some special kind of provisions are required in this regard, which are covered in this topic. So as I explained to you, auction sale has certain procedure to be followed. In this case, the auction is to be conducted either by the seller himself, or he may hire a professional auctioneer who may be working like an agent for that seller, and he may also be, because he is specialized in this field, he can also be hired to conduct the auction sale. But before the auction sale is to be conducted, due advertisement has to be done for the proposed auction, and even printed catalogs can be circulated for the same, and in that advertisement various terms and conditions regarding the type of the goods or other terms of agreement regarding price, the time and place of conducting of the auction sale, they are to be in detail informed to the proposed potential buyers. Then on the appointed date and time, the intending buyers will be assembling. They have to reach on time fixed for the auction, and then auctioneer will start conducting the auction by inviting bids from the potential buyers. Then potential buyers or intending buyers, they will be making bid. Making bid means they will be giving offer of a price, and then after every offer of the price, the auctioneer will be announcing or will be provoking the intending buyers to go for a higher price. So he has to prompt the buyers to bid for the higher price one after the other. So he will, after every one bid, he will announce the bid, and he will prompt new bids also from the potential buyers. So in this case, the price at which the bid will stop coming up next, that will be the highest bid, and the highest bid will be constituting as the final offer, and then that highest bid will be accepted by the auctioneer. And to accept this bid, he has to do some customary activity like fall of the hammer or announcing the price, like highest price was 1 lakh rupees. So he has to either, after announcement of 1 lakh price, he has to say 1 lakh 1, 1 lakh 2, 1 lakh 3, done. Or instead of that, he can simply make the fall of the hammer, or a bell may be rung. So all these customary practices can be used to announce that the highest bid has been accepted. So falling of the hammer is said to be acceptance, and the highest bid or all the bids coming up, they are said to be offers. But the final offer is the one at which we get the highest bid, and no further higher bid is coming up. So this is how the auction sale is conducted. Now there are certain rules to be followed with regard to auction sales, which are given under section 64 of the Act. First is completion of the auction sale. So I just informed to you how the acceptance is done with the fall of hammer or any other customary manner. So by doing all those customary activities, the auctioneer is kind of pointing out to the bidders that the auction sale is complete. That means the person whose bid has been accepted, with the fall of hammer, the sale completes with that person. So it is a completion of the auction sale, which means the ownership gets transferred immediately in the name of that highest bidder when the hammer falls. But any highest bid, if given, can also be revoked. Like we have done revocation of offer, because bid is an offer. So just like any other offer, this bid can also be revoked, and we call it retraction of bid. But this revocation or retraction of bid can be done only before the hammer falls. If once the hammer has fallen, then you lose the right of revoking the bid, because fall of hammer is acceptance, and we know very well that after an offer is accepted, you cannot revoke that offer. Transfer of ownership, as I explained to you earlier, in case the goods are specific goods, you know this, you were giving the bid for this very specific goods and they are in absolute deliverable state. Nothing is to be done on those goods and they are ready to be sold as it is. Then the ownership will transfer immediately the moment the hammer falls. But if the hammer has fallen, then auctioneer cannot modify the terms of auction. Just to prevent any kind of transfer of ownership, later on after the hammer has fallen, the auctioneer cannot make any kind of new terms and conditions added in the agreement. So only the terms and conditions which were specified in the advertisement of auction sale, only they will be held valid. And we have this case in this regard, Dennett versus Skinner. In this case, the highest bidder has given the bid and the hammer has fallen and the bid was in that case accepted. But afterwards the auctioneer said the ownership of the goods will get transferred only if you pay the price, and the price was paid in the form of check, and the auctioneer said only when the check will get honored, when we'll be able to get payment on the check, only then the ownership will get transferred. But it was decided by the court in this case that the transfer of ownership has already taken place when the hammer fell down. Third situation can be where the goods are not specific goods, like you have bought an old car and there was something left to be done into that car to make it deliverable car, like you have asked for repainting of the car. So in that case, even if the hammer falls, the transfer of ownership will take place only after that something to be done has been done by the auctioneer or by the seller. Next provision is right of seller to bid. Now in certain cases it happens that the bidders, they may have some kind of arrangement among themselves through which they may be preventing each other from bidding against each other, because when we keep on bid against each other, the price keeps on going higher and higher. So that is to the disadvantage of the bidders. So in that case, bidders may enter into some kind of knockout agreement wherein they will agree with each other not to bid against each other. Or in such situation, the seller will be at a loss, because in that case the price will not go higher and higher. And one of the objectives of conducting an auction sale is that you are able to procure the best price for your goods in the auction sale. So in this kind of a situation, to protect himself from lower price of the auction sale, the seller has a right of reserving the right to bid. He can expressly reserve the right to bid in the auction sale. He can appoint his own bidders also to take part in that bid. But for that, he will have to announce that in the prior agreement only. He cannot do it on the spot. He has to inform about this before the auction sale is conducted. That means in the advertisement itself, this clause has to be specified expressly by the seller. And in case the seller has not expressly mentioned that in the advertisement, and yet he has appointed certain bidders who are making bid in the auction sale just to make the price higher and go higher and higher. This kind of bidding is said to be pretended bidding, and these kind of bidders are said to be puffers. Puffers are the persons who are making fictitious bids. They don't intend to buy the goods, they only have been placed by the seller to enhance the price of the bid. Because the seller has not expressly informed about the same, so such kind of sale, if done, and the buyer was not aware about this kind of fictitious bids being made by the puffers, such kind of sales will be said to be voidable at the option of that buyer. So later on, when he comes to know about this, it will be counted as a fraud, and buyer will have to cancel the contract, will have the option to cancel the contract, because such contracts are said to be voidable as per the provision of this section 64 clause 3. So this is called the fraudulent sale. I just explained to you. In certain cases, to protect his interest, the seller also has this right to fix a reserve price or a minimum price for the bidding. But this also he will have to notify in the auction sale advertisement that this auction sale is subject to a minimum reserve price, which means that the auctioneer will have to start taking bids from that minimum price only, or he cannot sell the goods at a price lesser than this minimum reserve price mentioned by the seller already. In case he does so, it will be violation of his duty as an agent, because he was representing the seller and he was supposed to follow the instructions given by the seller for not selling the goods below the reserve price. In some cases, there are multiple stocks of goods to be sold at the same auction sale, and you cannot sell the entire lot to one buyer. Then you can sell the lump sum goods in small stocks, in small lots. So in that case, every lot will be put up for auction sale individually, and every lot will be considered as a separate contract of sale. Completion of auction sale, we have discussed already that it is on the fall of hammer. Pretended bidding, I have explained to you already. The puffers are making the pretended or fictitious bidding. Knockout agreement, I have explained, where the bidders, they agree among themselves not to bid against each other, so they can do so to protect their own interest. Damping. Damping is an activity which is done in case of an auction sale, where any person can try to dissuade the intending buyer from bidding. So it is said to be an unlawful act. You are discouraging that person to take part in the bidding by doing any of the following things. First, by pointing out any defects in the goods which might not be there in the goods, or by taking those bidders away from the place of auction, by scaring them, or by telling them about any other auction sale, any other kind of availability of similar goods, or by doing some other act in which case the bidder are not in a position to understand the right price to be proposed for the bid. So in that case, this activity is said to be damping, and if you are caught doing such activities, it is an unlawful act. Action can be taken against such persons. Transfer of ownership, we have discussed already. It happens at what stages in different cases. So these are the rules to be followed for the auction sale. There are certain matching topics also with this regard. First is implied warranties in auction sale. So like we have discussed implied conditions and implied warranties in the second chapter, in auction sales also, if there is any violation on the part of the auctioneer about the implied warranties that we have done there, in that case the auctioneer will be held liable for the same. So what kind of warranties he is giving impliedly? First is, he is warranting that he has authority to sell the goods in the auction sale on behalf of the principal. Principal here is the seller. That seller has given him authority to sell these goods through auction sale. So it is his warranty. Second is, he also warrants that he is not aware of any kind of defect in the title of that principal. Thirdly, he also warrants that in case the auction sale is complete, then he will be giving the possession to the buyer immediately against the payment of price. And last is, he warrants that the buyer will be able to enjoy quiet possession of the goods once the goods are sold to him. So these warranties means that these things must happen in this way only. But in case any of the warranties that he has given, they don't hold good, like the title of principal happens to be defective and the auctioneer was aware about this, or auctioneer was never given any authority to sell, or the auctioneer could not give possession to the buyer after completion of the auction sale. So in all these cases, we'll say that the implied warranty has been violated here. So in that case, because of this violation of the implied warranty, the liability will be falling on the auctioneer. So that liability will be that he will have to pay for the damages to the buyer in this regard. So these damages will be falling on the auctioneer because he has failed to perform his duty. So this was all about the topic of auction sale, and with this we also end with the Sale of Goods Act 1930.